Hello and welcome to Rights and Recourse, a program that tackles legal issues, bringing you information and analysis. My name is Dumile Mateza. Remember, you can also be part of our discussion today by tweeting us at Rights Recourse or calling our studio line on 011 714 5497 or 5498. Alternatively, email your thoughts to about this program and many others. And even if you want to suggest something, which issues we should tackle, please email to rightsandrecourse@sabc.co.za. The spotlight once again fell on fallen Paralympian Oscar Pistorius in an attempt by the state in the Supreme Court of Appeal in Bloemfontein seeking to overturn his culpable homicide conviction to murder. A full bench of 5 judges heard arguments from the State Prosecutor Gerrie Nel and defense advocate Barry Roux. Rights and Recourse will aim to elucidate the broader meaning in terms of law and layman language of Dolus Eventualis and a juxtaposition with Dolus Directus. Both state and the defense teams face tough questioning from the 5 Supreme Court of Appeal top judges, with Barry Roux attempting to keep the Olympian out of prison, while Prosecutor Gerrie Nel forcefully argued to the contrary.
The court ignored the evidence, the most important circumstantial evidence that will make the accused version not reasonably possibly true, impossible. If it did not happen, as he described, how he woke up, how he walked, how he moved the fans, then it did not happen how she left the bed. But the court just ignored it, and that's the most important issue.
Mr. Nel, what I find more troubling is how she dealt with Mangena's evidence.
Indeed.
She finds that he's an excellent witness, and if one reads the record, it's quite impressive on the cold record without having seen the witness and so on. But then you don't understand how she gets to where she does with the fact that she basically accepts what the appellant, what the accused said, that if he'd wanted to kill, he would have shot higher. Now, that is completely contrary to Mangena's evidence and his reconstruction. Indeed. So, I mean, the two never meet anyway. The finding that he's an excellent witness and he was never challenged, correctly so, and the ultimate finding in basically accepting part of the version of the accused. The two never meet, and that to me is very troubling.
It's unfair to say that the court just ignored evidence. The court took everything into account. And what we say, even so then, if we take that evidence and we say, now, what does it mean in the context of the case? Let's assume that the state, for purposes of today's proceedings, is correct. What would the screams mean? Would it mean that it gives rise to Dolus Eventualis? That cannot be. The screams has no relevance to Dolus Eventualis. The screams only had relevance to the state's main case.
Well, to unpack today's topic, we are joined in the studio by Mr. Michael Mutsueneng, who is a legal expert. We also are joined, we'd like to welcome Mr. Rian Lowe, an attorney specializing in criminal law. Gentlemen, welcome to the program, and thanks for giving us your time.
Thank you very much.
Question, first of all, I would like to know, both of you can have a bite at it, and that question is, after the judgment and sentencing at the trial, the prosecutor had to find grounds for appeal. What grounds were available to the prosecution?
Well, if you have a look at what the Criminal Procedure Act states, is that the state can actually be bound by only one fact on which they can appeal. They can only appeal on a point of law. That's the difference between the state and the defense. The defense can appeal on the merits of the matter and also the sentencing. But the state can only appeal on the basis that there was a there was an error with regards to a point in law.
And I think in addition to that, is how you determine what to appeal on is based on what you believe has gone wrong in the trial. What many commentators, myself, I think Rian included, we were quite surprised at the fact that Dolus Eventualis was not found to have been proven, because our understanding of Dolus Eventualis up to that stage was such that, given the proven facts, Dolus Eventualis was established. So Rian is quite correct when he says you can appeal on a point of law, but that point of law would have been directly related to Dolus Eventualis.
Excuse my ignorance on this case. When we talk about a question of law, what do we actually mean?
Well, in this regard, if we apply to this specific case, the argument was that the learned judge, Masipa, in fact erred by applying the principles of Dolus Eventualis wrongly. In this case, that he did not find that he did not have, or that he did not have the necessary Dolus Eventualis in order to convict him. And that is why with Dolus Eventualis you have to foresee if something is going to happen, if there's going to be some sort of consequence. And if you don't see it, then you can't be guilty of murder, because you can't have Dolus Eventualis. And Gerrie Nel is saying that the judge erred by not finding that. Yeah. On the other hand, Barry Roux is saying that the judge made a decision based on the facts. She considered all the evidence which was available to her, and that is what she found. So their argument is that it's not a point in law, it's actually a correct factual finding that was made by the Honourable Judge.
If you have regard to Gerrie Nel's heads of arguments themselves, they make a very important point, which I accept readily, is that it's very difficult to distinguish between what is a fact of law and an error in fact or an error in law, because the distinction is very difficult to draw. And let me give you an example of what it could be. When we're talking about an error in law, we're talking about a situation where we're asking ourselves, did you understand the legal principles? And we're not asking whether you, as a judge, correctly or incorrectly found that the accused person went to the door and fired 4 shots. So assuming that the judge had found that it's not 4 shots that were fired, it's actually 3. That would have been a matter of fact, because that's not what we're concerned about. It's how you interpret and apply the law to the proven facts.
Because of the fact that Dolus Eventualis is standing like a sore thumb in this case, I will go to that separately. I just want to cover some ground on many commentators believe that the deliberation of the Supreme Court of Appeal were not necessarily about Pistorius alone, but more about principles underpinning our justice system.
That's quite correct, because I don't think the case is in essence about Oscar Pistorius himself as a human being, and what he himself did is what the consequences is going to be if this point of law is not rectified. You know, there's various other cases which are still pending. There's cases which has been postponed by prosecutors waiting for this decision. Now, what happens in African law is if a matter is reported, it becomes a guideline. A reported case becomes a case which you can have a look at, and the way other cases should be decided upon.
Is this what we referred to earlier off camera about the case law?
Yeah. Case law, that's correct. Yeah. It's called case law. But you use those case laws if you've got a similar matter and you see there's a good decision that came out of a certain division or the Supreme Court of Appeal which covers the whole country, then you use that decision when you argue the matter in front of a magistrate or a judge. Now, if this case is not rectified, or the way in which the principles of Dolus Eventualis was applied, it means that there's other judgments that's going to come in the future that's also going to be decided wrongly. And that's why this case is so important for this African law system in the future.
The other question, Michael, is in his argument, the prosecutor raised the fact of circumstantial evidence that was ignored. And the question is, how important is circumstantial evidence?
In the ordinary course, circumstantial evidence is very important. And what circumstantial evidence is if me and Rian enter into a room and there's just 2 of us, and I come out of that room with bloodstains and a knife running out of that room, one can't tell what happened in that room if one finds Rian lying in a bloodbath. Sorry for the analogy. So we then resort to what we call circumstantial evidence to say the circumstances. We can't say for sure that Michael stabbed Rian.
In other words, what's happened before?
Or inside that room. But the circumstances before us tell us that you went in together and Rian was sound and normal, nothing had happened to him. But when you walked out with a knife. So the circumstances around that lead to a reasonable inference, and that inference can be that Michael has stabbed Rian.
Am I right if I say that evidence, circumstantial evidence, could be subjective?
Well, circumstantial evidence is very much subjective, because what is objective is something you can prove. It's subjective because you're putting together a series of what you, in your opinion as the decision maker or as the arbiter or as a judge, you're putting together those circumstances to arrive at a conclusion which you would believe is the objective and reasonable conclusion. So it starts off in some funny way as being a subjective one because one player is formulating the story, but to convict somebody it has to be objective.
I'm going to agree with him because he's got a knife in his pocket, it seems to me. But if you have a look at
for you.
if you have a look at dolus means intent.
Yeah.
Now it's very difficult to see into the mind of a person because you as a human being can't see what a person is thinking. The only way to do that is to look at surrounding factors, the way he acted, what he did, the testimony of other people who saw something which he did or which he didn't do, and that's the way the court then decides, based on circumstantial evidence, whether or not you had the dolus to commit a certain crime.
Yeah.
Well, I've been trying to avoid this dolus until I get to what I wanted to find out about Dolus Eventualis and Dolus Directus and Dolus Iratum and all of these other terms, these big terms that you guys are telling us. But when we come back, I want us to go deep into, take our knives and use them to go deep into Dolus Eventualis and Dolus Directus so that we understand it better. If you want to join us in today's program, you can please call us on 011 714 5497 or 5498 or tweet us at Rights and Recourse or email your thoughts to rightsandrecourse@sabc.co.za. Stay with us.
When bees and wasps sting a person, they inject a bitterness venom in their skins.
We have about 3 spider species in South Africa that we have to worry about. Right. Button spiders, which include, the black widow spiders, your sac spiders, and your violent spiders.
That venom is in your system, it's in your muscle tissue. And the more your heart beats, the faster your heart beats, the faster the blood is going to circulate, and consequently it's going to get that venom into your system faster.
If you see a snake like this, the best thing to do is to just stay away from it and contact somebody that specializes in removing venomous snakes.
Join me on Health Talk every Saturday morning between 9 a.m. and 10 a.m. as we unpack current health stories. I'm Peter Ndoro.
And I'm Rebecca Chetty Miller, SAB Miller, and Hauser Bush Imbev. It's something that I need to learn to say more often.
Will together produce around a third of the world's beer.
It is a mouthful.
Have you ever considered skin bleaching?
Nigeria tops the list of African countries with 77% of its women bleaching their skin.
Now I can see that it is not good because it affects my face and some of my body parts.
Thousands of Arab Israelis and Palestinians participated in a big rally.
Flight MH17 was shot down by a Russian-made missile.
How those chips may fall is a prediction best left to the currency of time.
That's Primetime News, Africa Journal, and Your World on SABC News.
Welcome back. We're still discussing the Supreme Court of appeal by Gerrie Nel against the Oscar Pistorius judgment. Gentlemen, what I wanted to know is I found a very cumbersome explanation of Dolus Eventualis when I looked through it. It's written in some Shakespearean language. Probably you can help us make it easier for my grandma to understand the tone.
I think the best place to start in explaining what it means is first to understand what murder means. When we're talking about murder, as a requirement for murder, we need intention. So before you can convict somebody, that person must be possessed of the intention to kill or to murder the individual. And it becomes murder when they know that it's unlawful to do so. Now, when we then distinguish between Dolus Directus and Dolus Eventualis, the distinction is simply the following. Directus is, as Rian said, Dolus means intent, and Directus means direct. So I have a direct intention, and it's A, taking a gun, pointing it at B, and shooting at B. That's Dolus Directus. Now, Dolus Eventualis is something different where it's not direct. It's for lack of a better word, indirect, and that's why we call it Dolus Eventualis. It eventually happens because, and we use a number of steps to say, you don't necessarily intend to bring about a result, you don't intend to kill B, but you want to do something else. And maybe let's use an analogy. If I light a fire in this dry grass, and I see that there's a car on my right that is in the grass, but I don't want to burn the car, I want to burn the grass. If I light, but before lighting, I think, you know, there's a possibility that in burning this grass, I might actually burn the car, but I reconcile myself to that eventuality, but I nevertheless proceed to light the grass, and the car burns. Then you've established Dolus Eventualis because then that reasonable person comes in. I beg your pardon, not a reasonable person, but foreseeability comes in, where you did in fact foresee, and you reconcile yourself to that possibility and proceeded with that act.
Rian, the other thing, this case was one of the problems that was standing in the way of the prosecution. These are Gerrie Nel's first words. We've got to go past over this bridge of the Siekui case law. What is the Siekui case law of 1982?
Well, the Siekui case was a case where the accused was charged with robbery, and then in the end of the day there was a competent verdict brought out on a charge of theft. Now, the accused tied up a woman in a house and stole her belongings, and the court held that because he didn't steal the belongings in front of her, it could not be a robbery, and then convicted him of theft. It's been a case that's been decided in 1982, and for 30 years now everybody's been trying to fix it and get that case law rectified in the future, because it was bad law, as Judge Stephen Majid said in the Oscar appeal hearing. The matter was discussed in the decision of State versus Basson, but it wasn't specifically discussed. It was merely mentioned in the case, where it was said that the Siekui decision was a bad decision. Now, what it entails to is that it stated that the state could not appeal a matter if there wasn't an acquittal, which means that Pistorius would have had to be acquitted of murder, and also of
culpable homicide.
Of culpable homicide.
Before
then
the
only the
state
state could appeal it. But basically, what the correct law is, and there's a Canadian decision which was referred to in the Supreme Court of Appeal, which stated that it would have been to the state's prejudice not to be able to appeal a case on the same grounds as a normal person would be able to do.
This Canadian case law, is it the Humphreys case law?
No, it's a different case.
It's a different case.
State versus.
I just want to go back to the Siekui case law. Was there Dolus Eventualis could it be proved in the Siekui case law?
I don't think so. I think the important thing about the Siekui case relative to this matter, the Oscar Pistorius case, is at what point, so that's the real question, in what instances can the state appeal against the judgment of a court, a lower court? And the Siekui judgment suggests that they can only appeal only in instances where the accused person was acquitted. Now, what is important to note about this case is that it is much longer before the Constitution, and the Basson case that Rian refers to is a case that is decided post the Constitution. And what the position is now, if regard is had to the Constitution, which enjoins the prosecution to prosecute matters and to bring about justice, one can't then find a reasonable basis upon which to preclude the state from doing its job simply because the individual concerned has been acquitted. And Judge Majid refers to this in a very simple way, but very clear. And he says, what if there is a patent or obvious issue that has happened where somebody who ought to have been charged for murder is eventually charged for a lesser, or is eventually convicted for a lesser offense, and the error is so obvious? Are we then to say there is nothing we can do about it simply because the individual concerned was acquitted? So that's what's important, and he then says that is bad law, and he says so because it's not bad because it's bad in view of now the Constitution.
You see, the Siekui matter didn't
Rian,
deal
I just want to go back to something else on joining what Michael was saying. Probably you can respond together to this one. It would seem to me, I know how charges are written. Charges are written, you are charged with murder alternatively for culpable homicide. In other words, in the Criminal Procedure Act, that's section 258 and 259. And it would seem to me the judge actually jumped 258 and went straight for 259 in this case.
Well, culpable homicide is a competent verdict. Now, the way I understand it, and Michael can maybe just assist me, I don't think that Pistorius was ever charged with culpable homicide. He was charged with murder. But how it works in law is if you cannot find enough grounds to convict a person of a certain charge, you are welcome to look at a lesser charge, which is a competent verdict. And this is what happened here. The judge went straight towards the competent verdict.
Yeah. In fact, if you took a step back and you remembered Gerrie Nel's arguments, they were nothing to do with culpable homicide. He didn't at all allege any negligence on the part of Oscar Pistorius. In fact, he went further than that, even further than Dolus Eventualis, and said there was Dolus Directus, because that's why the evidence for him about the screams was important, because he wanted to say Riva Steenkamp was running away from Oscar Pistorius, which of course proved to be a great hurdle for him.
Why was it necessary for the state to appeal the interpretation of Dolus Eventualis? I think you have answered that question, but let us just get it clear. Why did he point his fingers at Dolus Eventualis?
Well, if you don't rectify the situation, as I said, there's a lot of cases which I personally know has been postponed, waiting for this judgment to be clarified, because the Supreme Court of Appeal is the highest court of appeal in the country. Now, they set the rule, they set the bar with certain decisions, and those decisions need to be followed by the lesser courts, going down to the normal Supreme Court and then going down to the magistrate court. So if a magistrate wants to look at a certain matter and decide which way to go in it, he will have a look at reported matters, case law, and then that will guide him to come to the correct decision. If the case law is flawed, you're going to have a continuance of bad law going forward in the future.
And perhaps just to make it absolutely clear, if a magistrate is dealing with a matter that has been decided by a higher court, even if he feels that it was wrong, there is nothing he can do about it. He has to follow it.
The other question that was on many people's lips, could the appeal by the state be construed as an issue of the punishment must fit the crime?
Well, definitely. Because if it's a case of murder, then surely the punishment must fit the crime. And in this case, I went on record stating that at the time when he was sentenced, that I felt that the sentence was a proper sentence with regards to culpable homicide. Because if one look at the case law, which says what type of sentences you can impose for culpable homicide, the case law says yes, you can impose section 2761I. But if you look at murder and you look at the case law with regards to murder, you are looking at direct imprisonment. In fact, there's a minimum sentence that's been set by the Act on Minimum Sentences.
Well, we will go back. I know Michael wanted to say something there. We will go back. When we come back, we'll talk about the role of the Supreme Court of Appeal in this case and many other cases. But if you'd like to join us, talk to us here. You can call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse, or email us at rightsandrecourse@sabc.co.za. Stay with us.
This is Rights and Recourse.
This act says we are all the same, we are all equal before the law.
I have a fundamental problem with her saying that traditional leaders are recognized as the de facto owners of the land. That isn't in the Constitution, nor is it in any law.
Unpacking your legal rights and cost of action.
The Constitution starts from the point that we are one country and that we need to have a system that actually consolidates that, but also recognizes the different compositions of different communities.
With respect to Aninka, I know she is happy that her queen in England, she's the owner of the whole land, she's not having any politics.
Chief Mokoena, we will get to some of the other issues.
You must withdraw that Aninka's Queen of England please, that's completely unacceptable.
That's Rights and Recourse, Sundays at 2 p.m. on the SABC News channel.
News at 1 touches the nerve of business locally and abroad. Find out how a move in the economy affects you daily. We bring to you all stock markets information across the globe daily. We deliver the latest news and sport news of the day. Make a date with lunchtime news at 1 daily.
Welcome back, and now let's hear what the Twitter committee has to say on this matter. Looking at General Chinamo, he says it means the perpetrator actually foresees the possibility of his act causing death and persists regardless of the repercussions. That is what Dolus Eventualis is. I think that's a very direct explanation.
Yeah, that's correct. But in the law, it's applied with two legs. The one is to have the actual subjective foreseeability, and then the second leg is then the subjective reconciliation with the actions. So it's correct the way it's stated there, but you first have to get past the one leg before the second leg can come into play.
The other issue is, Michael, this appeal by the state has actually brought the role of the Supreme Court of Appeal into a full circle.
I think when I was watching the proceedings, it's one of the things that make you very proud, not just our legal system, but as a country. Because it's an illustration of how justice is at different levels. I mean, you know, this has been a very long, I mean, it's been long for Oscar Pistorius, but for the viewer out there, it indicates just how much trouble goes into protecting your individual rights. And this is a protection of not just Oscar Pistorius' rights, but those of the victims and those of the society, because it becomes very important when we talk about justice having the need to be seen to be done. And this is, to borrow your words, full circle insofar as demonstrating that.
Well, yes, Rian made a comment earlier and said the Supreme Court of Appeal is the highest court you can appeal to, because somebody wrote and said it has more gravitas, the seats are more plusher, and the wood is more cleaner and nicer, and the judges are more combative.
And juxtapose that to the magistrates' court, where you'll struggle for aircon.
It became very clear, Rian, that during the proceedings, that the Supreme Court of Appeal, that our law is in good hands.
Yes, I just want to say one thing with regard to your previous comment. Actually, you can also appeal to the Constitutional Court, yes, but then it's going to raise constitutional issues. I was talking about criminal law, the highest court to go with the criminal cases to the Supreme Court of Appeal in Bloemfontein. Yeah. But if you have a look at the case of Oscar Pistorius, my feeling is that there were so many issues, there were so many legal principles that was dealt with in this case. And you know, it made all of us sometimes go back to the books, sometimes have a look at the case law and reinvest our interest in these type of cases, because it was so interesting, and everything was dealt with in a very, very professional manner, from the bail application right through up to the Supreme Court of Appeal. And it actually, as Michael has said, it makes you proud to know that the law is working, that the judicial system in South Africa is in good state.
I was looking I was watching the appeal myself, and I saw there's more light in the Supreme Court of Appeal. And if you compare it to Pretoria, the North Gauteng High Court, it was a little bit darker.
Well,
Well, the main thing is that it doesn't have an accused doc, the Supreme Court of Appeal, because the accused doesn't have to be there when the judgment or when the case is heard and the judgment is given. He only finds out via his legal representative what the result of the appeal is.
What I hear from the discussion that we are having now today, does it then mean if the state is unsuccessful in its appeal, Judge Masipa's interpretation of Dolus Eventualis will stuck in our law books, and the lower courts will have to abide by that interpretation, as you said earlier?
Absolutely. That's exactly what will happen, except if there is a constitutional issue, then the state would be in a position to take it to the Constitutional Court. This I would doubt very much to be the case. I know Rian has a contrary view insofar as whether there are any constitutional issues that may arise. But I doubt that very much. So it could very well be the final court to hear this matter.
The other thing is the role of the Supreme Court of Appeal here is very clear. They have 5 judges sitting there, and each one of them obviously has been given a role. Is it not the case, or is it just by accident that each judge asks certain questions and others are sitting and listening?
When you appear before a presiding officer, every presiding officer has to make up their own mind. They have to apply their own mind to the facts and the law. And that's the luxury and that's the reassurance that you get as somebody who appears. And it's 5 for a reason, because if you remember correctly, there was a lot of this unhappiness on most of South Africans saying, but this was too lenient. Judge Masipa was too lenient in just giving 5 years, which is actually, which he only has to serve 1/6 of in prison. And what this does is that you're not just questioning the decision of one individual. You then have an opportunity to be heard by 5 individuals who each of them are enjoined to apply their own mind. So they're all independent. And if you look at the questions that have been asked, they're all different. Some of them you could read that they're more inclined towards the state or state's argument, and some of them are more inclined towards the defense's argument. So all of them are very independent. And once the group makes the decision, and the decision is made by majority, then I think there would be a greater ease in accepting the verdict that would emanate from a judiciary constituted as such.
But even if there's a dissenting voice,
yes,
that view is put into the judgment.
Absolutely.
Yeah, you only need 3 against 2. And it's correct what he said. I mean, each judge got his own personality. Every person sees things in a different way. So now what happens is, instead of having one brilliant legal mind in front of you,
yes,
you've got 5 different legal minds. All of them different backgrounds, all of them different experience, because sometimes you get a judge got more civil experience than the other judge has on criminal law. So now what you now get is you get a mix of experience, and you get a lot of years of experience.
Yeah.
I mean, there should have been maybe 200 or 250 years of experience between those judges, and you can't falter with that.
There's another thing that I observed during the trial, and Barry Roux tried very hard to paint the prosecution into a corner by saying the prosecution is suggesting that the judgment was a fragmented judgment by the judge.
I'm actually
by the trial judge.
I'm intrigued that you've picked that up, because that's exactly what he sought to do. He sought to redirect the argument, because he could see that the conversation on whether firing 4 shots into a small cubicle would remove the possibility that somebody could foresee that somebody could be shot. And he sought to redirect that and take the argument back to the heads of argument of Gerrie Nel by then referring to the various evidence that was laid. And what he intended to do by that is to then go back to the argument of whether this is a question of law or whether it's a question of fact. And what he was arguing is that Gerrie Nel at all times had been raising questions of fact and disguising them as questions of law. And so I'm actually quite impressed that you picked that up.
The other thing, Rian, was the uprightness of Judge Majid. When Judge Majid came on and immediately said, I'm actually strange that your heads of argument do not include the Mangena evidence, because Mangena was seen by the trial judge as an implacable witness, but all that evidence was ignored.
Well, that's why I say, you know, when we talk about the heads of argument, let me just explain what heads of argument is. That's basically the argument of each of the parties which they present to the court. Now, the defense has heads of arguments, and the applicant, the state, has heads of arguments. But there's also certain issues which the judges may pick up, which is not in those papers. And this is a good example of experience, of a clever legal mind who picked up something which is not in the papers, and they are allowed to also bring that into the whole question and the whole debate. And that's what he did. He raised a point which was not basically on the table, but which he also thought needs to be addressed.
I read somewhere that the Supreme Court of Appeal is not a sentencing court, and correct me if I'm wrong, that the Supreme Court of Appeal is not a sentencing court, but reading through the powers of the SCA, Section 322, subsection 1 reads, in the case of an appeal against a conviction of any question of law reserved, the Court of Appeal may give the judgment as sought to have given, and the judgment was that was ought to have been given in the trial, or impose such punishment as ought to have been imposed at the trial.
That's what I understood the Criminal Procedure Act myself to be saying, that the Supreme Court of Appeal can indeed replace the conviction as what it ought, or what it believes ought to have been imposed. But listening to the appeal, Justice Majid was clear in saying the Constitutional Court has now decided on the issue and has ruled that in fact the Supreme Court of Appeal can't impose any sentences. They can make a finding on the guilt or otherwise, that is on the conviction issue, but just not on the sentencing issue.
Let's go back to a caller from the Free State, Galax from Free State. Galax, good afternoon and welcome to Rights and Recourse.
A very good afternoon, sir.
Yes, sir. What's your question?
Yeah, actually, I just want to contribute in as far as the whole case is concerned. From a layman point of view, I think Judge look in the important factors that one locks herself inside the toilet with her cell phone. And number two, the history of Pistorius anger, and also Pistorius actually, according, he was a trigger-happy man. Get what I mean?
I hear you. Okay, thank you, Galax. Is that all?
Yeah, no, that is not all. And I also think that if he claimed that there was an intruder, Pistorius should have checked thoroughly for him. And I think Judge Masipa was a weakest link in as far as the case is concerned, as far as her judgment was concerned. And then I think these 5 other judges are going to apply their mind correctly and instruct Judge Masipa to resentence for murder.
Thank you very much, Galax. Galax raised a couple of things that his phone broke up sometimes, but the gist of his discussion, of his issue was River went to the toilet with a cell phone, and that was raised in the trial, and also the fact that Judge Masipa did not rule, did not take that into account, and all of that, and that's what he's saying.
Yeah, I think what Alex is just restating to us is basically the circumstantial evidence. Yeah. It all amounts to circumstantial evidence, and there's a need for the court to look at it and to make a better decision on this based on the circumstantial evidence.
And I think Galax picked up on another point that was raised by the judges to Barry Roux, and there was a very clear question which is troublesome for any defense team, and it said, in firing 4 shots into a cubicle of that size, because there was nowhere else to hide, in other words, the intruder had nowhere else to hide, in firing 4 shots, it would have been quite miraculous if the person inside was not shot. And that's what Galax is picking up on. And once you then appreciate that and you accept that as a proven fact, and I think it was Judge Leach who then said, in fact, there was no room to stand behind the wall. So there was actually, it was inescapable that you would be shot. If you accept those, then how then do you then escape liability on Dolus Eventualis? And that's what Galax picked up on. But the other thing that Galax raises is the issue of sentencing. And he then says it must be taken back to Judge Masipa to resentence, which won't happen. It has to be taken to somebody else, a different judge.
Let me go back to something else. Without preempting what the Supreme Court of Appeal might be deciding, what avenues are open to the Supreme Court of Appeal? I think you touched on one from Galax.
Well, before you explore the avenues, you got to then go back to what are the grounds for appeal. And the first ground is that Dolus Eventualis was inappropriately interpreted, which that's always been my view, and that's always been Rian's view as well. The second issue is on the circumstantial evidence. So the first point is I think that they will find that Dolus Eventualis was not correctly applied to the proven fact. And the second issue that Gerrie Nel raises in his heads of argument is the issue of circumstantial evidence. I don't think that he's going to succeed on that one, because I think he might be falling into the trap of talking about questions of fact. The final one is the inconsistent versions that are given by Oscar Pistorius. You can't have multiple defenses, because how then do you say the version of the accused was reasonably possibly true if he's offered you three? And the difficulty which the judges appear to have picked up on is, of the multiple defenses that are offered by the defense, the judge, for some reason, elects one.
Let's hold it there, but we will come back, and when we come back, we'll talk about what should we expect from the Supreme Court of Appeal, and also the double jeopardy principle. Don't go away. We'll be back after this.
Media Monitor, the title says it all. Can we really afford more job losses at such a critical time in our economy? Join our panel of experts as they unpack and monitor all the leading and breaking news stories making waves in the print and social media platforms. It seems we don't have a famous son-in-law any longer. Levi, what do you say to this? An A-lister.
I'll leave this one to Levi. He's the romantic.
Watch Media Monitor with me, Alicia Jali, Sundays at 9 a.m. only on the SABC News Channel.
Health Talk, your show on health practice.
The people being empowered with knowledge so that they can change their behavior and reduce their risk of being sick.
How serious is stress at work?
If we don't address workplace stress, that negative stress, then it can lead to burnout and it can lead to depression.
How does absentees affect companies?
The one that's really problematic for employers is the one that is unscheduled.
How can companies organize their wellness program?
Health promotion mustn't just be a one-size-fits-all type of approach. It must be customized based on understanding of the unique needs of that particular organization.
For health tips that will help you to adopt healthy living with Dr. Sello Mutawung on Health Talk every Saturday.
Welcome back. Let's once again go to the Twitter committee and see what they have to say on this matter. There's a great deal of debate on Twitter. Pilani says, I noticed that Advocate Roux ignored the question whether it was okay for Oscar to shoot at anyone other than the deceased. Silo Mateza, I think that it will be better if the matter is ventilated before the Constitutional Court. And Free Palestine says, yes, the trial judge's interpretation was incorrect. Oscar intended to kill the person in the bathroom. That is murder. Gentlemen, Pilani is making a very strong statement. Probably you are in agreement with what Pilani is saying.
Yeah, no, I think Pilani has got a future in the law. He picked it up correctly. Well done to Pilani.
Silo Mateza is looking at it completely differently.
Michael? I think, depending, if you go back to what we said earlier, only if there's a constitutional issue, then it would be necessary for the Constitutional Court to hear the matter. But we got 5 judges. I think that should be good enough, because we also want to bring finality to this.
Maybe just to give an indication of what would be considered a constitutional issue. Maybe something like Oscar Pistorius didn't have a proper or fair trial because of the media coverage that came into play in this case. So that might be a constitutional issue. Yes. So you have to colour it in as a constitutional issue. It can't just directly go to the court.
The other question I have, can the court order a retrial? And the defence has actually brought to the fore very strongly the principle of double jeopardy. And what about double jeopardy if there's a retrial?
Well, my argument on it is that the court has not yet gone full circle. It's flowing out of the conviction from the Supreme Court to the Supreme Court of the Appeal, and it has to be rectified. So it's not a new case and a new charge that's been opened. It's still the same case. It's still flowing, and the legal avenues has not yet all been exhausted. So once you get to the Supreme Court of Appeal and they make an order, that order needs to be followed to the T. And that forms part of the Criminal Procedure Act, Section 324 and 322, which orders in which way the court can intervene in those decisions. So it's not a new action that's instituted. It's still flowing out of the proceedings that came out of the original case.
So what double jeopardy means is the rule says you can't try an individual twice in respect of the same facts. Now, this would not be twice, as Rian said, because it's still one process. It just went back. It didn't start anew. So it's not two separate processes. It's just the same process having picked up an issue, an error, where we say, let's just go back. It's like you're reversing, but we haven't reached our destination. Our destination is reached once you've exhausted all the remedies available, and those remedies are from the High Court, you go to the Supreme Court of Appeal. From there, if necessary and if appropriate, you go to the Constitutional Court. So once you've done that, it means nobody can, in 2 years' time, come and restart this process.
The other thing for me, to what extent, depending on which direction the court will be going, the Supreme Court of Appeal will be going, will this trial and this appeal restore the public's confidence and faith in our judicial system?
Well, I think the public wants to know whether or not the right decision has been made, because obviously it's now in the news and the media that there is an error or suspected error, and they want to see how it's going to be rectified. And they want to see, we as jurists want to see that the situation is rectified and that the proper decision here with respect to Learned Judge Masipa, that the correct application of Dolus Eventualis is applied here, and that the law at the end of the day, that it's set right, and the way forward is set out in the judgment of the Supreme Court of Appeal with regards to decisions regarding Dolus Eventualis.
I think just to add to that is, one can't say justice is when one wins. Justice, that's not justice. Justice is when all the parties to the dispute have been given an opportunity to ventilate their issues. In other words, somebody has been accused and the accuser has met the accused and vice versa, and then a decision has been made. Not all of us are going to be happy with the decision one way or another. Some of us will be unhappy and some of us will be happy. But if the unhappiness is well grounded in law, then you would have recourse to higher courts such as the Supreme Court of Appeal. And if you don't agree there, then it just means your viewpoint was not supported by the Supreme Court of Appeal. It doesn't mean that should have a bearing on your confidence in the justice system. I think what we've seen is an illustration of a perfect, world-class, first-class legal system. You can't get this. You get this in first world countries, and this is what we've demonstrated.
Well, when we come back, we'll look at the final closing statements on this issue. It's been a fascinating discussion so far, but don't go away. We'll still have one more segment to deal with in this discussion. Stay with us.
Looking for social issues?
It is not our intention to give condoms to 10-year-old children.
We are here to assist you. Looking for religious issues?
The point is not for the church to try and prove whether this is the fact.
So we want accountability. Is there a system of governance in your churches?
Political issues.
Barack Obama said Africa should stop looking to the outside for salvation and focus on someone else being at fault for the problems of the continent.
Economic issues.
The young mothers, single mothers that's buying property now.
Or just looking to air your views.
Here are some of your views on social media.
Look no further. as Newsroom has all the informative information you need. Weekdays at 9 a.m. only on the SABC News channel.
Welcome back to Rights and Recourse. We discuss the appeal court decision, the appeal court proceedings that took place on Tuesday last week in Bloemfontein. But let's take this call from Pumza in the Eastern Cape. Pumza, good afternoon and welcome to Rights and Recourse.
Afternoon, how are you?
Fine, thanks. How are you?
Good, good. A quick one. It's a question for me. What happens if this court finds that Thokozile Masipa made an error? So if, let's say, Oscar is sentenced for murder, he's already served a couple of months, what's going to happen? Is that going to be taken into account to say, let's say, for example, they sentence him 15 years. What's going to happen? Because now he's still serving, but he's at home if he's found guilty of murder.
Thank you very much, Pumza. That's a question I had, actually, at Pumza, saying what happens if the court says, okay, it's... I think we get a sense, we don't have to preempt the Supreme Court of Appeal, but we get a sense that they are saying there's an error that's been made in law.
Well, there's case law that says that actual time spent in custody or sentence should be taken into account. And the case law says it should be multiplied by 3. There's case
Can you repeat the prescribed sentence period?
The prescribed sentence period is 15 years for murder.
So that's a minimum sentence.
It's a minimum sentence, yeah, that's imposed.
So in other words, despite him serving less than a year, that will count as the first 5 years that Judge Thokozile Masipa sentenced him?
No. It's the actual time spent. So if they gave him a sentence for 5 years in terms of section 2761I and he only sat in jail for 9 or 10 months, the actual time spent, the 10 months, not the 5 years, will be multiplied maybe by 2 or 3, and then they will arrive at a figure and say, let's, according to the case law, we will take that into account, and that will be compelling circumstances to deviate from the minimum sentence, because the Minimum Sentence Act states that you have to present compelling argument and reasons to deviate from the 15 years. Yes. So they have to prove that to the sentencing officer.
Michael, earlier, I think this will be this will form part of the guidelines from the Supreme Court of Appeal to the Pretoria North, to the North Gauteng High Court for another judge to do the judgment.
Yeah, the sentencing. The same matter cannot go back to Judge Masipa because she's what we call functus officio. It's out of her office now. It's some other people must now deal with the matter. So if the appeal is successful and the Supreme Court of Appeal substitute the conviction with that of murder, then they would have the discretion to revert the matter back to the High Court, in which case a new judge would be appointed who would deal with the issue of sentencing, and what that would entail is that evidence would be heard in mitigation or aggravation from both sides. So this would be an instance where again we see Oscar Pistorius coming in to give evidence in mitigation because now the conviction is different. And one other thing is that the circumstances of Oscar Pistorius have naturally changed, given the fact that, amongst other things, he served some time. And how that is dealt with is it doesn't influence the sentence that is imposed on him, but certainly in computing the number of months or the number of days that is to serve, they would then take into account what he's already served. So the 15 years is the minimum sentence for murder, but only in exceptional circumstances can you go lower.
If I understand you clearly, you say the the defense should be given another opportunity to come and give evidence in mitigation.
Yes.
The aggravation will be the decision of the Supreme Court of Appeal.
No.
So
the aggravation will be the evidence that would be tendered by the state. And on the point of aggravation, I can't imagine that there is anything further that the state can adduce as aggravation, because
exactly, that's what I'm saying.
But certainly the defense can adduce a great deal, because a lot has happened, as a matter of fact, both to his career and his family life, etc.
Well, the simple practical thing is also that he's now been found guilty of a different offence. So what you would reason in front of the court to be compelling reasons as required by the Act is different, because it's a different offence.
As I was driving in quickly into work this morning, I saw this headline, the evidence might put Oscar in jail, and I thought this is new evidence around. And when I read the paper, I found that now they're talking about the Mangena evidence. And I think that is a very strong weighting on this trial.
Well, if they talk about the Mangena evidence, I think that Judge Majid has basically indicated that they should have taken more cognizance of his evidence, which means they should have attached more weight to it. And because of the more weight that's been attributed to it, the court has to look at it more intensely. Yes. And that might be a little bit of a form of aggravation, because it might state that he had ample opportunity not to do what he has done if the court finds that. It's once again circumstantial evidence which is going to prove the dolus or the intent of the accused.
I would submit that it's not at all new evidence. This is the exact reason why there's an appeal for Dolus Eventualis, because Mangena said the shots were fired at the torso of the individual behind the cubicle, and you fired at torso because you may want to kill.
Gentlemen, thank you very much for your time. This has been a rather riveting discussion around this issue. This has been Rights and Recourse. This program is repeated at 5 on Monday morning. Do find us on Twitter and on YouTube. From all of us here in the studio and the rest of the team, thank you to our guests, and goodbye, should we say.